Good afternoon. Thank you for joining us this afternoon. My name is Catherine Saldana. I'm one of the mentor attorneys with the Dallas Volunteer Attorney Program. Today, we are fortunate to have Kalisha Rutledge, who's the managing attorney for the Home Preservation Project for Legal Aid of Northwest Texas. For the past 10 years, Kalisha has specialized in landlord-tenant law and guardianships. While at Landwit, Kalisha has served as a mentor to DVAT volunteer attorneys as well as other attorneys. She has served on several task force and as Landwit's housing practice team for the last 3 years. In recent months, she has helped coordinate community education for tenants facing evictions by doing outreach at the courthouse. Kalisha?
Thanks, Catherine.
You're welcome.
So I'm gonna try to get through all of this material in an hour, or actually less than an hour, so that you can have time for questions. So I might talk really fast and completely ignore some sections, but it's my understanding that you have been provided the PowerPoints, or if you haven't received them already, that they will be sent to you. So like Catherine said, my name is Kalisha and I'm the managing attorney of the Home Preservation Project. And we're going to be going basically through evictions and give you kind of a crash course. So the first thing we're going to talk about is an overview of the eviction process. And this is an overview. So what happens is the tenant violates the lease agreement, or is considered a holdover, meaning they stayed beyond the expiration of their lease agreement. The landlord should then give them a notice to vacate. Once that notice to vacate has been given, the landlord is going to file a petition for eviction in justice court, or you might hear me call it JP court. After that's done, the landlord is going to get a trial date and the citation is going to issue. The eviction trial is going to be set within 10 to 21 days. And the only issue is possession, who has the superior right of possession, and is rent owed. At that eviction proceeding, the landlord is either going to get an eviction judgment for possession or they're going to lose. If the landlord gets a judgment for an eviction, the tenant is going to have 5 days to appeal to county court. If they don't appeal within those 5 days, the landlord is going to get a writ of possession, and we'll talk more about that during the presentation. And if a writ of possession is signed by the judge, then it's going to be executed by the constable. So let's go ahead and start and talk about the lease agreement. Lease agreements can be written or oral. When we are talking about a lease agreement, we're trying to see, does a landlord-tenant relationship exist? If it's a written lease agreement, that's great proof. Here's the written contract. Here are the terms. Yes, there's a landlord-tenant relationship. A lease agreement can also be oral. And for that, you can show proof. If you have been giving your landlord, if you've been paying rent and they've been giving you receipts, but there's no written contract, but there was an oral agreement that you were going to stay in this property and you were going to pay $500 a month, those receipts that you give to the landlord every month, that's going to be proof of your oral lease agreement. And I gave you the definition of a lease. That's just any written or oral agreement between a landlord and a tenant that establishes or modifies the terms, conditions, rules, or other provisions regarding the use and occupancy of a dwelling. And that's found in the Texas Property Code. Sometimes you have to think, is this person a guest or an invitee and not a tenant? If they are a tenant, you do have to go through the eviction process. If they are a guest or an invitee, you do not have to go through the formal eviction process, but sometimes it is recommended to protect the landlord's interests and everybody's interests. But there's no formal eviction process needed. One example is Auntie M does not have to evict Dorothy because she was just a guest or an invitee. She can just simply throw Dorothy out and change the locks on the premises. If you are a motel or hotel guest, you might be considered a guest. You might be considered a tenant. It kind of just depends on the circumstances. If you have been at that motel or hotel for a long period and your payments are made monthly or even bi-weekly, there may be an argument that there is a landlord-tenant relationship that exists because of the duration of your tenancy and the frequency of your payments. Now, if you've been staying at that motel for the last week and you pay weekly, chances are you're going to be a guest and not a tenant. And if you are a guest or an invitee, the hotel or motel do not have to evict you. They can just simply change the locks or change your key card so that you can't get in. There are different types of lease agreements. There can be a fixed term tenancy, or there can be a tenancy at will. And a tenancy at will is one where a landlord-tenant relationship, but there aren't any specific terms to the tenancy. And this is important to understand, as a verbal agreement to let a friend or family stay with you may create a tenancy at will and will require formal eviction proceedings to get them to move out. You can also have a periodic tenancy, like a month to month. Some practical tips about a lease agreement. If there's no lease agreement, then title may be at issue. And if title is at issue, then eviction suit cannot continue or proceed. What would happen is you would have to file a plea and abatement to the court and let them know, hey, title is at issue. And what that JP judge should do is should abate the case while title gets settled. And the title issue should be taken up in district court or county court, not JP court. If a tenant didn't get a complete copy of their lease agreement when they signed it, an eviction suit can be abated if a landlord does not give a copy. This does not apply to non-payment of rent cases, but other lease violations. And the premise is, if you signed a lease agreement, but you didn't give that tenant a copy of the lease agreement, you're saying that they violated the lease agreement, but how do they know they violated the lease agreement if you did not give them a copy of the lease agreement when they signed it? So you can get the case abated or basically put on hold if the landlord didn't give your tenant a copy of the lease agreement, if it's for a violation of the lease agreement. Next, we're going to be talking about violations, and there's kind of two categories of violations. There is non-payment of rent and everything else. So for non-payment of rent, I always tell my clients and applicants that if you are a day late or $1 short, then you haven't paid your rent on time. A lot of people think that a grace period is their due date, but it's not. It's just that. It's just a grace period. Most lease agreements is going to say that rent is due on the 1st. They might give you a grace period until the 4th, meaning that if you pay rent between the 1st and the 4th, or the 2nd through the 4th, you might get a late fee, but they might still accept your rent. But if you don't pay on the 1st and you try to pay on the 2nd, 3rd, or 4th, even though there is a grace period, they still don't have to take your rent. So I always tell people, make sure you pay your rent when rent is due, and the due date is in your lease agreement. For a landlord to be able to collect late fees, it has to be in writing in the lease agreement. I always tell people also that they want to check for a payment or application of funds clause. There are some lease agreements that basically say, if you turn any monies into us, we are going to be able to apply those funds to whatever we want to first. And this always comes into play when, say, you are behind on rent and there is a $50 late fee for, let's say this month is May. So let's say you didn't pay May's rent on time and they charge you a $50 late fee and your rent is $1,000. When you go to pay rent tomorrow on June 1st, they are going to take $50 out of that $1,000, and they're probably going to apply it to the late fee balance that you had in May, which is going to cause your June rent to be $50 short. And if they do have late fees in their lease agreement, then what they'll do is they'll charge you a late fee for June So a lot of people think that they are paying their rent on time and in full, but because of the payment or application of funds clause, the landlord is taking that money out and applying it to late fees owed before applying it to rent. So it gets tenants in a lot of trouble. There's also no obligation to remind the tenant about late fees if it's in the lease agreement. If there are no late fees in your lease agreement, then that landlord cannot collect late fees. And you'll see some landlords, not most, but some that are very, what's a good word? Slum landlords. They will try to charge late fees, even though it is not in their lease agreement, and that is not allowed. So that's one category of violations. The next category of violation is basically everything else. That can be criminal activity, drug use, damaging property, unauthorized occupants, unauthorized pets. Those are usually kind of the, I guess, top 5 or 6 violations that I see. Just some practical tips is to make sure that you read the lease agreement to see if it's an actual violation. Sometimes landlords will give people notice to vacate or lease violations for things that aren't actually in the lease agreement, they just don't like. So just make sure that it actually is something that they violated in the lease agreement. You can also see if a reasonable accommodation could excuse that violation. And some examples of when a reasonable accommodation can help you overcome a lease violation is that, say, rent's due on the 1st, but that tenant doesn't receive Social Security, or that tenant receives Social Security, and they don't get their Social Security check until the 3rd of the month. Rent's due on the 1st, they don't get paid on the 3rd. What you can do is you can put a reasonable accommodation request in writing and ask the landlord to basically let you pay your rent on the 3rd of each month instead of the 1st, because of the reasonable accommodation. You don't get your Social Security check until the 3rd. I see a lot of people that get lease violations for pets. They say an apartment complex and there's no pets allowed, but they have an emotional support animal. An emotional support animal is not considered a pet. And you can ask for a reasonable accommodation, basically to have that emotional support animal in your unit, even though pets are not allowed at the lease. The last reasonable accommodation request that I've seen that has helped is sometimes we have tenants that have mental issues, and maybe they are off their medication for a certain period of time. And during that time that they are out of their medication, maybe they have an outburst or they do something that a normal tenant would get a lease violation for, let's say just yelling at a neighbor. If you can show that that tenant does have a mental disability and they were off their medication during the time period that happened, you can ask for a reasonable accommodation for the landlord to excuse the lease violation of yelling at a neighbor and overcoming that violation. So I just talked about rental accommodation or reasonable accommodations, but I kind of wanted to give you guys a little more in depth about it. So FHA is the Fair Housing Act. It prohibits the refusal to make a reasonable accommodation in your rules, policies, practices, or services when such accommodation may be necessary to afford a person with a disability the equal opportunity to use and enjoy a dwelling. And a person with a disability is one of the 3 of these things. It's either an individual that has a physical or mental impairment that substantially limits one or more major life activities, or it can be an individual who is regarded as having such an impairment, or an individual with a record of such impairment. And a person does not need to be on disability benefits to meet the definition of being disabled. It's probably, more proof, but it's not the end all be all. And a reasonable accommodation is a requested change, exception, or adjustment to a rule, policy, practice, or service. When you're making those requests, they can be either verbal, written, or accompanied by a letter from a medical provider, and they can be made at any time before the tenant is physically evicted from the rental property. I always tell people, always make your requests in writing. It's really hard to prove verbal requests. So just go ahead and put it in writing. That can be, a text message, an email, a letter. A letter is preferable. I think so. That's the best practice. So next, we're going to talk about a demand for possession, which you guys will probably know it as a notice to vacate if you haven't done evictions before. But basically, a notice to vacate has to be an unequivocal demand for possession. It needs to be in writing. It should not be via text or email. And it has to be delivered properly. And there are 4 different ways that you can deliver that notice to vacate. It can be in person, handed to an actual person or tenant that is 16 or older. It can be affixed to the inside of the front door, not on the outside of the front door where someone can just come by and just take the notice off. It needs to be on the inside of the dwelling. They can send it by mail, or if the landlord is going to affix it to the outside of the front door, it needs to be in a sealed envelope. That envelope needs to be marked important document, and a copy of that same notice that's in the envelope needs to be put in the mail the same day. If the notice to vacate isn't delivered in one of those 4 ways, you'll have a defense to your eviction. So some practical tips. Make sure the landlord has gave enough notice. Sometimes a landlord will say, I'm giving you 30 days, a 30-day notice to vacate, and they go and they file the eviction on the 25th day. If they do that, then you have a defense to your eviction because they didn't give you the right amount of time in their notice to vacate. And how do you know how much notice needs to be given? It depends on the lease agreement. If the lease agreement is silent, the Texas Property Code says you have to give a tenant at least 3 days. Most TAA lease agreements, the Texas Apartment Association agreements, the notice requirement is 24 hours. So look at the lease agreement, see how much notice the landlord has to give. If the lease is silent, property code says they have to give at least 3 days. If the tenant is in a subsidized property, then there are going to be extra requirements on that notice, and typically they get longer amounts of time. You also want to make sure that the notice to vacate was delivered properly and it can be verified. A notice to vacate sent via text or email does not count. A notice to vacate that was slipped under the door or in a crack of the door or put on the side of the door with a little clip does not count either. If you're representing the tenant, have that tenant take a picture of how they found the notice to vacate so that you can use that in the eviction citation. Usually a maintenance man or another employee delivered the notice, not the actual property manager that is going to show up for the eviction. So if that other employee or the maintenance man doesn't show up to court to testify to that delivery, you can always voir dire the landlord on their personal knowledge of how the notice to vacate was delivered. If they can't prove it, then the judge should dismiss it. That's not always the case, depending on the JP. Like I said earlier, you want to make sure they waited the correct amount of time stated in the notice to vacate before they file the eviction suit. like the example I gave, if they gave 30 days to move out, but they filed on the 20th day, they filed the eviction prematurely, and you can ask the court to dismiss that case. So now we're going to talk about the eviction suit itself, and that's called a forcible entry and detainer suit, or you might hear the judge say an FE&D suit, depending on what JP you're in front of. For an eviction suit, you want to remember that the landlord has the burden of proof. The defendant can go in and say nothing. If the landlord doesn't prove their case, you can ask for that case to get dismissed because they didn't prove up all the elements of the eviction. If only one party shows up, then that party wins by default. If the landlord shows up and the tenant doesn't, the landlord is automatically going to win. If the tenant shows up and the landlord doesn't, then the judge is going to dismiss that case. Or I should say the judge should dismiss that case. There are some JPs that will are a little more landlord friendly. And what they'll do is they'll reset the case. I think if you're representing that tenant, you ask that the case not be reset and that the case be dismissed, because it's the landlord's burden to prove the case. And if they don't show up for trial, then it must not be important to them. And if they really want to, then they can refile their lawsuit. The loser pays the court costs and attorney fees if awarded. And the court cannot award anything other than possession of the premises and unpaid rent if payment of rent was alleged. The JP should not take into consideration late fees in the judgment, repair costs, damages, any other type of fee except for rent and possession. So that hearing is going to be not less than 10 days from when the landlord filed it, and it shouldn't be more than 21 days after the lawsuit has filed. So if the judge does try to maybe give the landlord extra time, you can point to the rule that says eviction cases need to be heard between 10 to 21 days. In the lawsuit, it must include a description of when and how the notice to vacate was delivered. If for some reason the constable goes out and is not able to serve the tenant with the actual eviction citation, they can request that an alternative method be awarded or be ordered. And that has to be served at least 6 days before the day set for trial. And what the constables usually will do is they will usually take the citation and they will tape it to the front door, or they will rubber band it around the door handle. For eviction cases, non-attorneys, you don't have to be represented by an attorney to do an eviction case. You'll see a lot of landlords that will have a third party representing them in court. And if a party wanted to be represented by, say, their brother to speak on their behalf, then that's allowed also, because you don't have to be an attorney in eviction cases. So some practical tips. Do not give the landlord ammo for their case. Make them prove it up. A lot of times I have seen tenants and I've had clients that are very upset with their manager, and the manager might say something and the tenant will interrupt, and they're basically digging themselves in a hole when they should just, just not say anything. And when it's their time to talk, then they can, disprove whatever the landlord say, but don't give the landlord ammunition to help their case. Always make sure that you prep your client and your witnesses, advise them to keep quiet, tell them that they shouldn't do the don't roll their eyes, and only answer questions that are asked of them. Do not elaborate unless asked to do so, because usually when they start talking, they mess up. So make sure you guide them on how to listen to the question and only answer the question that they are being asked and don't give anything more. Another practical tip is know when to negotiate when opposing counsel or the landlord. You can consider an eviction hold-off agreement. An eviction hold-off agreement is basically, you can have two different types. You can have one type that says, you know what, my client doesn't want to go through with the eviction. If they agree to move out by, June 15th, can we go ahead and dismiss the eviction if they move out? Some landlords are willing to take that because they don't want to go to court. The other type of eviction hold-off agreement is when there is a non-payment of rent situation. You can say, hey, what we'll do is we'll enter into a payment arrangement. My client will pay this amount of money on these dates to become current. If they become current within the amount of time and don't miss payments, you'll agree to dismiss the eviction, and some landlords will go off of that. So just consider negotiating those eviction hold-off agreements. And I can send Maricela and Catherine copies of those eviction hold-off agreements if you guys would like a sample to use. The last practical tip I would say about evictions are there are no counterclaims in an eviction suit. The only thing that they're talking about or the judge is going to consider is possession and rent if it's at issue. Anything about security deposits, repairs, illegal towing, those all come in play in a separate lawsuit, not the eviction suit. So now I'm going to talk about some of the most used defenses for an eviction. Some common defenses are if they're alleging payment of rent, if they're alleging non-payment of rent and you have actually paid the rent, that's a defense. Retaliation, defective notice or no notice, proving up the delivery of the notice, illegal discrimination, novation, the landlord is not the correct party to the lawsuit. If title is at issue, unclean hands, filing prematurely, and family and domestic violence are some common defenses. To appeal your eviction, there is a 5-day deadline. If either party loses, they have 5 days to appeal that lawsuit. And this deadline does include weekends and holidays. If the court is closed before 5 p.m. on the due date, then the deadline extends to the next business day. So in reality, they get 6 days instead of 5. I always tell people, I always give them the 5-day deadline because I just don't want them to try to go that extra day. And the court says, oh no, yeah, we're, the clerk's office was closed, but we accept tenants appeals until 5 o'clock, but we just close everything else. So I always tell them the 5 days and make them rely on that. To appeal, you can either post a bond or you can file an affidavit, and that affidavit is called a statement of inability to pay. If it's a non-payment of rent, you have 5 days to appeal by filing that statement of inability to pay. Once you file your statement of inability to pay, you have 5 more days to put 1 month's rent into the court registry if the tenant wants to stay in the apartment or in the unit while the case gets appealed to county court. If it's just a lease violation, they have the 5 days. They can appeal with a statement of inability to pay. They won't have to pay any money. If it's not payment of rent, they have 5 days to file their statement of inability to pay. Once they file that statement of inability to pay, they have 5 days to put 1 month's rent into the court registry if they want to stay in the unit while the case goes to county court. If they plan on moving out, but they still want to appeal because they don't want an eviction on their record, you can advise them, well, then don't pay, the 1 month's rent. But just know, if you're in that unit and you don't pay the 1 month's rent, a writ of possession can issue and the constable will come out and basically put you out of the property during that time. When the case gets appealed to county court, it is a trial de novo, meaning you get a whole new trial. And the tenant can request that an attorney be appointed for them, but the court is not required to give them one. I usually see some judges in county court appoint an attorney ad litem to tenants in eviction cases when they're going up against the housing authority, or there's some other special circumstances like the person has a disability. So I'm going to spend some minutes talking about kind of COVID-19 and all the various orders that are in play. First up is the CARES Act, and this basically helped borrowers with federally backed multifamily mortgage loans. If they experience financial hardship caused by COVID-19, they had the opportunity to request a forbearance of their loans through the earlier of the national emergency or June 30th, and this is for homeowners. So if you were a homeowner and you had financial hardship, you could have requested a forbearance. Now, following the expiration of the forbearance, that borrower or homeowner may not require a tenant to vacate the tenant's unit before a date that is 30 days after the date on which the borrower provides the tenant with the notice to vacate. So basically what happened is, if the homeowner is backed by a multifamily mortgage loan, and there's a website that you can look at for that, if there is a tenant in that property that has a multifamily mortgage loan, that tenant has to get 30 days notice to vacate. That's basically the crux of that. So the next big thing is the City of Dallas COVID-19 ordinance. If you are in Dallas, this is very beneficial to the tenants and residents of the City of Dallas. And knows this only applies to City of Dallas residents. This does not apply to Dallas County residents that are outside the City of Dallas. So if they have Dallas, Texas in their address, then it applies to them. Basically, the purpose of this notice is to enable residents that are unable to pay their rent to work collaboratively with their landlords to make payment arrangements. So before a landlord can send a notice to vacate for non-payment of rent to a tenant, they must first send the COVID notice of possible eviction. The notice will let the tenant know that they have 21 days to provide documentation or verifiable information that the tenant is unable to pay rent due to a negative COVID-19 financial impact. The tenant who provides that proof to their landlord will then have 60 days from the date of the notice to work out a payment plan, apply for rental assistance, or make other plans to cure the delinquent rent. So they get the COVID notice, they have 21 days to provide the landlord documentation. If they do so, then they get another 39 days or so. I'm not good with math. 60 minus 21 days to either enter payment plan, apply for rental assistance, or try to cure that delinquent rent. And during that 60-day time period, the landlord is prohibited from sending a tenant a notice to vacate. Now, if the tenant does not reach out to the landlord within those 21 days, when that 21 days expires, the landlord can then give that tenant a notice to vacate for non-payment of rent. A tenant can also send a notice to their landlord either via email, text, letter, or other form of written communication of a negative COVID-19 impact. And if that tenant sends their hardship notice to the landlord before the landlord sends the COVID notice of possible eviction, the time periods are still put into play. They get 21 days from the time they sent their notice. And then they'll get another 39 days to try to work out a payment plan, apply for rental assistance, or make other plans to cure the rent. So the Texas Eviction Diversion Program, it's really it's in play, but it's not in play. They don't have the people that were doing the Texas Eviction Diversion program were the Texas Rent Relief program, but they don't have any more funds. So in lieu of the Texas Eviction Diversion program, we have a emergency order that kind of substitutes any type of rental assistance for the Texas Eviction Diversion program, but I included the link if you wanted to get more information on it. But basically how the TEDP works, or the latest emergency rental order, is that both parties, the landlord and the tenant, can agree to apply for rental assistance to resolve the eviction suit without proceeding with the actual trial. Parties can sign an agreement and file it with the court, and basically the case is going to be abated while the parties seek rental assistance. And if successful, the case is going to be sealed and dismissed. So we're going to talk about the 50th Supreme Court of Texas emergency order, which kind of replaces the eviction diversion program. This basically says that a non-payment of rent eviction citation must include the following language. You may be able to have some of the rent you owe paid and stop your eviction. At the eviction trial, the judge must allow representatives from legal aid organizations to be present in person or remotely to provide information, advice, intake, referral, or other assistance to eligible litigants. I will let you know that even though there is a Supreme Court order that says this, there are still some JPs that will not allow legal aid into their courtroom because they think it makes them seem like that they are pro-landlord, pro-tenant. So they want to remain neutral, so they don't want legal aid in their courthouse. The judge must also confirm whether or not the plaintiff has any pending applications for rental assistance, or they have provided any information or documentation directly to a rental assistance provider for the purposes of their tenant receiving rental assistance. If rental assistance is available, the judge should discuss the available rental assistance programs and procedures. They should also ask if the parties are interested in participating in available rental assistance programs. If the plaintiff or the landlord has a pending application for rental assistance, or the tenant and defendant both express an interest in participating in a rental assistance program, the judge must immediately abate the case for 60 days. They should also make all court records, files, and inform the parties of their extension. Oh, they should make all court records and files confidential, basically sealing the record. And they should inform the parties of extension, reinstatement, and dismissal procedures. So the eviction gets abated for 60 days. The judge may extend the 60-day abatement period at the plaintiff's request, but just the plaintiff, not the defendant. And each extension should not exceed 60 days. If the landlord wants to reinstate an abated case, they must file a motion to reinstate with the court, and they have to serve a copy of the motion on the defendant. In that motion, it has to show that the application for rental assistance or participation in rental assistance has been denied, canceled, or withdrawn. There are some landlords that are just filing the motion, but they are not showing that the rental assistance application has been denied, canceled, or withdrawn. If that's the case, that's not a proper motion to reinstate, so that case shouldn't be reinstated. But once they do file the motion and they serve it on the defendant, the judge must sign and serve a written order that basically reinstates the eviction. That means they're going to make it they're going to take it off of being confidential. They're going to set it for another trial date. They're going to give you the procedure for action to proceed. And they're also going to make all court records and file non-confidential. If though the landlord doesn't file a motion to reinstate during those 60 days, the judge must dismiss the eviction and any claims with prejudice on the 61st day. And they shouldn't require either party to file a motion or make a request, and that file is going to stay sealed. This works out a lot in our favor. We convinced the landlord to try to enter into some type of rental assistance with the landlord. We'll actually file the rental assistance application. During that time, the clock's running. And on that 61st day, if the landlord hasn't filed a motion to reinstate the eviction gets dismissed with prejudice, which means that they cannot refile an eviction for any of the months that they claim rent was owing for that eviction, which is really great. If the plaintiff doesn't file the motion, the judge is going to dismiss with prejudice the day after abatement. File is going to stay sealed. The parties can inform the judge of their willingness to participate in the Texas Eviction Diversion Program as long as a writ of possession has not issued. So say, for example, there's an eviction, tenant owes 3 months of rent, tenant doesn't have a defense, they go to eviction, they go to the actual trial, judge rules for the landlord, gives them judgment of the premises and the back rent for 3 months. The tenant has 5 days to appeal. They appeal. They have 5 more days to put 1 month's rent into the court registry. If at all during that time, the tenant can convince the landlord to enter into a program, they can do so. And what the judge is going to do is he's going to set aside the judgment that he entered. He's going to make all the court records confidential. And he's basically going to sign an order stating the procedures to apply. So a tenant can get evicted and still get their case abated as long as a writ of possession has not issued. And a writ of possession is basically a court order signed by the judge saying that the landlord has a superior right of possession of the property. And once that's issued, then the constable is going to execute it, meaning they're going to go to the apartment or the residence. They're going to stand outside and they're basically going to make sure that the peace is not disturbed. And that landlord can take all of the tenant's items and put them out on the curb or put them in storage, but they will basically take all your belongings out of the unit. That's basically what a writ of possession is. So as long as a writ of possession hasn't been issued, the parties can enter into the eviction diversion program and get the case abated. Once the writ of possession has issued, though, that is off the table. This order does expire on July 1st, unless it's extended by the Chief Justice. So I'm going to kind of quickly talk about federally subsidized housing, vouchers, and public housing. There are different types of federal subsidies. There's public housing, subsidized housing, different types of vouchers, Section 8 vouchers, veteran affairs, supportive housing vouchers. Generally, though, there's greater protection and there are more obligations on the landlord. If you do come across a tenant that has some type of federal subsidy, I would recommend that you guys reach out to Catherine as soon as possible so that she can team you up with an attorney that is familiar with federally subsidized housing. So I'm going to kind of differentiate between public housing and Section 8 housing. With public housing, the landlord is the Public Housing Authority, or the PHA. They basically have a 10-day notice of proposed lease termination. The tenant can request a meeting with the landlord to address issues before they actually get evicted. And the landlord must do certain things before any notices are required by the lease. And the tenant may have a right to a grievance process. For Section 8 vouchers, is different. There is a lease agreement between the tenant and the homeowner. There is a HAP contract between the homeowner and the public housing authority. And then there is basically an agreement between the housing authority and the tenant. So it's kind of like a triangle. If there is a conflict between the lease agreement and the housing assistance payment contract, which I called it a HAP, or most people call it HAP, not just me, the HAP is always going to control. So if the lease says, you know, the landlord has to give 3 days notice, but the HAP contract says the landlord has to give 10 days notice, then that landlord has to give 10 days notice instead of the 3-day notice instead of in the lease agreement. Landlords have to send a notice to vacate to the public housing authority at the same time that they send the notice to vacate to the tenant. They have to keep the public housing authority updated. And a landlord cannot evict a tenant for non-payment of the public housing authority's portion. So some eviction prevention practical tips. I'm not going to read these out to you guys. I'll read out a couple. Make sure that you understand the lease agreement. Always tell the tenants to show up for court, to communicate with their landlord, and to make a paper trail and document everything. Those are things, I guess, the highly mentionables. So, any questions? I'm going to look at the Q&A and try to go through questions at that time. The first question was, what are some red flags that signal a slum landlord in your experience? I would say landlords that don't want to do a written lease agreement. That always makes me wonder, you know, what's going on. Landlords that don't give rent receipts when people pay their rent. Those are just some red flags, I guess. And on the tenant side, what are some red flags? I would say tenants that tell you one thing but then give you written documentation of something else. So, you know, now it's a red flag. Are you being honest with me? I think those are some red flags. I also think that tenants that do their background and they know the law better than me, that's a very big red flag. When tenants are throwing around legal words, that's a red flag. The next question was, is it possible to evict on a lease to purchase agreement where default due to non-payment, or must it be foreclosed? I think it depends on the lease agreement, and I would have to see it to properly answer that question. I'm sorry. Is it possible to evict a tenant due to criminal activity alone? Of course. That is, you know, a lease violation. If the criminal activity occurred on the property. Now, if they go and rob a 7-Eleven, you know, 5 miles from the house, I'm not really sure how that would break their lease agreement. But if it occurred on the property, then yes. Let's see. The next question said, I stated that the loser pays the court costs. Are there any exceptions or monetary assistance you are aware of for those losers who are indigent or very low income? No. There are no monetary costs that can help them. They definitely can file a statement of inability to pay that will waive all the waive all the fees to appeal. But most of the times when landlords get those judgments against tenants for money, it's literally just a piece of paper. They're never going to collect from that tenant ever. So if you appeal, though, that eviction judgment goes away. So if you go to county court, and I probably should have put this in the slide. Anytime there's an eviction and you appeal, the JP judgment goes away. And the county court judgment is going to take its place. A lot of times, if a tenant wants to move out and they don't want to fight the eviction, I still tell them to go ahead and appeal, because what's going to happen is if they appeal, they move out. When the county court trial comes along, that landlord probably isn't going to show up because the tenant has already moved and they got what they wanted. But if the tenant shows up and the landlord doesn't, then the tenant can ask for that case to get dismissed, even though they're not in the property anymore. So I think that's a good tactic. This says, when can a landlord change the locks? So it depends on the lease agreement. Most landlords are going to put in their lease agreement when they can change the locks, but there is a process. They have to post a certain notice on the door. If they do change the locks, they have to place a notice on the outside of the door that basically gives the tenant a number that they can call 24 hours and get access to a key to get in. And if they don't, then the tenant can file what's called a writ of reentry in the JP court that basically says, I stay in this place. Yes, I didn't pay rent. Yes, I owe rent, but I call this number. The landlord won't give me a key to get back in. And I need to get back into my property. And the landlord will basically sign an order making the landlord give you a key to the property, whether you pay rent or not. That's called a writ of reentry. The next question is, what should an attorney do if after the eviction case has been filed, he learns that there is an executory contract? I would tell that attorney to contact Catherine to get paired up with an attorney from either the Home Preservation Project or from Dallas, Maine, so that they can walk you through it, so you don't miss anything. The next question is, if a client is on Dallas Public Housing Assistance and they are behind on paying their portion of the rent, what are the rules on late fees being added to the eviction? Same thing. Evictions are only for rent owed, not late fees. Oh, I think I lost my place. Okay. Next question. Are landlords obligated to pay for services such as air duct cleaning that the landlord has not approved and the tenant has done? I think I'm kind of confused. If the tenant has already done it, would the landlord be obligated to pay for it? Probably not. Most lease agreements will state that the tenant has to go through the landlord to make any repairs to the premises. But I would need to see that lease agreement to answer your question better. The next question is there an argument for a tenant to avoid or minimize eviction if he or she can show other tenants are treated differently from the tenant being evicted, notwithstanding the language of the lease agreement, such as discrimination? Yes, discrimination is a defense to an eviction, and I myself have used that and gotten an eviction dismissed. So yes, that is a valid defense. Next question, are there any special rules for manufacturers' homes or mobile homes? Yes. They have their own property code section. If the occupant on the mobile home is not the registered owner of the mobile home, the JP typically grants evictions on the basis that the occupant is not the named defendant or tenant. Usually the eviction is titled and whoever is staying at the premises or who's on the lease agreement. So say Jane Doe owns the lease agreement, but they are leasing it out to Maricela. The owner is probably going to file the eviction in Jane Doe and all occupants, which is going to cover Maricela because she's an occupant in the home. Next question, is self-help a common issue? I think you mean, do landlords routinely evict tenants without going to court? And yes, that is common and it is not allowed. And a lot of tenants don't know any better to come and, talk to an attorney about it, but self-help is not allowed. Let's see, next question. If an eviction is dismissed, can a landlord sue in district court for late fees? So late fees, the landlord's probably not going to file another lawsuit. What the landlord is going to do, let's say tenant is behind 3 months, $500, so $1,500 total. Let's say late fees for each month is $50. They're not going to get awarded that $50 in the eviction citation, but what's going to happen is the landlord is going to put the rent that's owed and the late fees on that tenant's credit report, which they can do. So I don't think, I've never seen a landlord, file a lawsuit for late fees. They usually just they put it on the tenant's credit report and try to get it that way. But if they did want to get late fees, that would be a small claims lawsuit. I'll let you handle that one, Maricela. Let me see. Let me go to the chat and I'll try to answer. Maricela, do I have a couple more minutes or?
Yes, we do have a couple more minutes, so you
Okay.
can more than welcome to answer a few more questions.
Awesome. Okay, so in the chat, it put, what are the remedies for being wrongfully evicted? Would it go through small claims court? Yes, it would basically be a lawsuit for wrongful eviction, and you can get damages, and yes, you can, depending on the amount, you can file it in small claims court or county or district court. Okay, I think I answered that one already. Can the PowerPoint be sent via email? I am sure that we are able to do that. I think I answered the question about special rules for manufactured homes already. Maricela gave you guys the CLE information. Next question, is it true that once you've been evicted or have an eviction filed against you, your name goes on a list, which makes it virtually impossible to rent from a TAA property again? So once an eviction has been filed against you, there are lots of tenant reporting agencies that pull that information and they basically store it. And a lot of landlords basically use these companies when they're running a tenant background search. So yes, a person who has been evicted, or if an eviction has even been filed against you, not necessarily, you lost the eviction, your name is floating out there and it may be harder for you to rent in the future. Yes, that is correct. Usually what happens is the landlord will charge a higher security deposit, or they'll charge you a high risk fee because you have had an eviction filed against you before. Next question is, can a landlord evict a tenant for past due rent, even if now the tenant is paying rent on time and the landlord is accepting rent? So a landlord can only evict for rent owed. So I'm sure I have seen landlords try to evict for past rent. Yes. Even if you didn't pay your rent. Oh, wait. Can the landlord evict the tenant for past due rent if the tenant is now current on rent? If they're current on rent, I'm not sure how they would be able to evict for past due rent. I think the judge would be very upset with that landlord that is trying to evict a tenant for past due rent that was owed but is now current. They're current on rent now, then an eviction shouldn't go through. But yes, landlords have tried to do that in the past, but make sure you tell the judge, no, they're current and have proof. Let's see, is there a help group for attorneys involved in an eviction or foreclosure? Maricela, Catherine, there's a housing and consumer task force through the state bar that you might be able to
We
get
can
on.
look into it.
Yeah. That's the
We
only
can look
one.
into it.
Yeah. I'm on that one. It's the consumer and housing task force. I don't know if it's for legal aid organizations or it might be extended out. I'm not sure, Catherine, to pro bono attorneys as well. I'm sure you guys will be able to join also.
We can look into it for sure.
Okay. Let's see. The next question is your status on the eviction list forever. Once you get reported to an agency, when does it expire? Yeah, it's basically kind of a list that never goes away. The problem is once you get it removed from one tenant reporting agency, there are like 5 more out there. So you would have to go to each tenant reporting agency to try to get your name removed. And there are probably 100 in Texas alone. So it's kind of hard. The next question is, a wrongful eviction lawsuit separate from the eviction suit, or should wrongful eviction be claimed as a defense? And a wrongful eviction suit would not be able to be a countersuit. It would have to be its own separate lawsuit. But you can use the fact that you are being wrongfully evicted as a defense